Advanced care planning is the process of reflection and communication. It is simply a time for you to reflect on your values, your wishes, and let your loved one and the people around you know what kind of health and personal care you would want to receive in the future if you were unable to speak for yourself. What it is not, it's not a conversation about dying, or it's not a conversation around palliative care. Rather, what it is a conversation starter, right? It's allowing your loved one, being able to share your wishes and your values with your loved one, with the people that you live with your family and friends, initiating this advanced care planning conversation without igniting fear, right? How do we introduce the conversation? Do we pay attention to some of the concerns? Where are these concerns coming from? What are the barriers? What is hindering us from having these conversations? And then when we look at our worries, is it our worries that we're projecting on our loved ones, or is it both? These conversations are very important and they need to happen. It's non-judgmental and it's more of a supportive role, right? How could we get these conversations started? You know, how'd you set the mood? How'd you set the tone? Well, there's no right answer. You do whatever works for you, right? Do you start these conversations after a nice supper when you and your partner are washing the dishes and just having a nice time together? Or is it when you guys are out having a walk? It could be that maybe you're not married. Maybe you're a single individual. Maybe you have this conversation with your close friend, with your best friend. Or can it be that you're having this conversation with your sibling? Whichever your situation or your household situation is, it doesn't impede you and it doesn't refrain you from having this conversation. My personal preference, you know, nice dinner on a terrace top somewhere downtown with a nice glass of wine, I would like to start this conversation. But you do you and you do whatever works for you. How can we bring about the conversation? What are some tips? Well, you could leverage a most recent experience, right? You could say something like, oh, you recently had some changes in your health. You know, there might be some health-related decision that you will need to make in the near future. Is that something that you would like to explore? Or could it be that, you know, you recently had a trip to the hospital? Maybe start by saying, you know, during your recent stay at the hospital, can you tell me more about your experience? How did that make you feel? What did you like? What did you not like? The care that you received, you know, did you appreciate it? Was it of value to you? What's important for you? You know what? We never had this conversation. I've never even asked you the question about, you know, if anything were to happen to you, how would you like to receive care? So these are all conversation starters, and you could seize the momentum if you have one to get the conversation going. If you don't have one, create that atmosphere where you bring on these questions in a non-judgmental, but rather in a supportive way, and more of an open-ended conversation where you learn and you explore each other's wishes and values. So what does it mean to be mentally incapable or incapacity? The inability to make your own decision is called incapacity. Incapacity impacts your daily life, but there are ways that you can protect yourself to ensure that your choices are being respected. In other words, it's the state of mind where the person is unable to make decisions for themselves. This can be temporary or indefinite. This can be due to short-term medical illness, a medical diagnosis, or it could be as simple as an intoxication. Your substitute decision maker can only make your healthcare related decision on your behalf only when you are not mentally capable. On the left side of the screen, I've given you situations in which an individual might not be mentally capable of expressing their wishes or being able to advocate for themselves. What I've put in blue is short-term situation, which means they are reversible health-related incident. So it could be due to delirium. It could be intoxication due to drugs or alcohol. It could be an infection that's leading to confusion. The other ones, a degenerative disease such as Alzheimer's, Lou Gehrig's disease, ALS. It could be a head trauma. It could be a motor vehicle accident. It could be a stroke. You could be going for a walk, going for a run. You do a faux pas, you slip, you hit your head on the concrete ground, you find yourself unconscious in the hospital for an indefinite amount of time. How would you like to be taken care of? On the right side of the screen, I'm giving you example of some types of decision that your substitute decision maker can make. Surgery, whether to have invasive or non-invasive surgery. Administration of certain medication. Consent to receive treatment. Maybe you're a Jehovah's Witness, maybe you're not. Maybe you need to receive blood transfusion. Is this something that's in line with your wishes? Is this something that's in line with your values? Maybe to stop treatment, start or stop life support, housing and accommodation, admission to a retirement home, a group home, a long-term care home, right? These are all decisions that your substitute decision maker will have the ability to make for you. An example, I had a 25-year-old patient that went to deliver via C-section. Unfortunately, the phrenic nerve got touched. She ended up being completely paralyzed all the way from the neck down. Unable to decide for herself, unable to make her health-related choices. She can't stay at home, she can't stay in the hospital. Unfortunately, her SDM made the decision that she was going to end up in a long-term care home. Can you imagine how that would be or feel for this individual once, let's say, she awakes from the coma, if she did awake from a coma, being 25 and finding yourself in a long-term care facility? Would that be something that you think she would have liked? Well, to prevent all of these things, that is why it's important to start the conversation earlier on. So let's look a little bit deeper into what is a substitute decision maker. Advanced care planning serve predominantly as a guide for your SDM. In Ontario, how you wish to convey your wishes can be made through a variety of ways. It could either be verbal, you could write it down, you could record it, you can choose whichever way you want. If you write it down, my recommendation would be to type it out and ensure that your loved one and your SDM knows where you keep that information. Please keep in mind that SDM rules regulating advanced care planning and substitute decision making is province specific. So this is Ontario specific. Your SDM must consider your most recent wishes. It doesn't matter if you wrote it down or not, if you had written it down or you had this conversation in a prior time and you've written it down, and most recently you had the conversation and you shared with your SDM some of your health wishes, your SDM has the duty and the responsibility to go with your most recent wishes or choices. If you do not choose to write it down, that's okay. Communicating with your SDM is the most important things in order to support and help them, guide them, for them to make choices in your best interest when you are no longer able or capable of. Their responsibility, like I've mentioned, is to act in your best interest, to make the right decision for the individual based on their values, their wishes, and their goals of care. Some things that they need to consider is, does the benefit outweigh the risk or the harm? Is there a less aggressive option that might be beneficial? What if, you've got a patient or it's an individual, it could be somebody that we know, it could be your loved one that is late 20s, has a health outcome, needs treatment, part of the side effect of this treatment the medication that she will receive will cause her to be infertile. Meanwhile, this individual has not had kids yet or children yet, but you know that this is something that's of value to her. What do? Do you go ahead and allow the healthcare professional to proceed with the treatment, or do you withhold the treatment and you explore other options? What if it were to be a hysterectomy? So these are all situations that explains and underlines and highlight the importance of having an advanced care plan, right? And speaking and appointing who your SDM is or who your power of attorney is. And we're going to get into that in the next slide in order to really support them. Because when you are no longer capable, when you're incapacitated, or you don't have the mental ability, the person that you choose is the one that's going to be stepping in on your behalf and making those decisions for you. Now, if you find yourself with a health outcome that is reversible, that's temporary, do you want to wake up from your hospital bed knowing that you've got a limb missing, or that you no longer have a hysterectomy, or that there's a decision that has been made for you that does not align with your wish, your values, or your choice? What does quality of life mean for you? Because quality of life and quality of living is different for each individual based on where they find themselves in their life. So in Ontario, there is a substitute decision maker hierarchy. Legally, everybody in Ontario automatically has a substitute decision maker. That is the one that you see here in the middle. It could be your spouse, it could be a parent, it could be children, it could be siblings, or it could be any other relative. If you choose to appoint a power of attorney of care, the power of attorney of care, the POA, automatically trumps your automatic SDM. So you could decide that you don't want your spouse to be your SDM, you're going to appoint a parent, or you're going to appoint a friend, or you're going to appoint a neighbor. Whomever you decide to choose and you make it official as your power of attorney, they will trump this SDM in the green category. In the event that, let's say, you did not have a power of attorney, it goes in order of priority. So the court can appoint a guardian. If you don't have the POA, it will go to your spouse. If you're not married or you're not in common law, it automatically goes to your parents. If your parents are not living, but you have children, it will go to your children. If you don't have any children, you don't have any parents, you don't have any spouse, it goes to your sibling. If you don't have any sibling, it will go to your closest relative. Let's say you don't have any of these in the green category, then the last resort is the government will appoint a public guardian and trustee.
I can listen to this.
So let's look at what are goals of cares. Goals of cares are basically how you would like to be taken care of, the type of treatment plan that you would want. What is acceptable for you? What is not acceptable for you? What can you compromise on? And what is an absolute deal breaker? If you look on the right here, this is an individual that has a PEG tube. What does this mean? This means this is your only source and way of receiving nutrition. You're going to be eating through this tube, and the meals that you're going to get is through liquid form. You will no longer have the ability to ingest anything by mouth. You could have it directly, the PEG tube goes directly into your stomach, or you can have an NG tube here, which the tube is stretched.
18 people in attendance, that's not bad.
Yeah. So it goes directly through your nose, and that is how you're going to be fed. What if you have any one of this? These are ostomies. An ostomy is a surgically created opening that reroutes the intestine, the colon, or the bladder into a pouch outside of the body. Ostomies are put in place for different reasons. It can be permanent or it can be temporary. What if you woke up and you ended up with a permanent ostomy? Or perhaps a tracheostomy? If you did not have this conversation and your significant other acted in your best interest, thinking that, you know what, we're going to go with the option that is most viable, that's going to save your life and prevent any further complication. You woke up and this is now going to be one of these items here. It's now going to be how you're going to be living for the rest of your life. Is this something that will be acceptable for you? Is this quality of life? Is this quality of living? These are just a few examples, but there could be other examples. You've got an athlete, somebody that loves to run, loves to do outdoor sports and activities. Wake up to see that they've gotten a partial limb amputation. What do you do then? I had a patient that ended up with this situation right here. The spouse, the wife ended making the decision in the best interest of what she thought was for her husband and for her household. When the husband woke up from his condition and realized that he was going to have to deal with this pouch, he could not accept it. As a man, this was unacceptable. He did not see how he was going to live day in, day out with a pouch that collects bodily fluids. He did not want to do the care of it because the care is quite extensive. For him, he developed an altered body image perception. He fell into a very, very deep depression and never came out of it. His whole life was shattered and he was no longer the same person that he was. In order to prevent all of this, I know these are difficult conversations to have, but these are conversations that we need to have. So a bit of some reflective questions. What does quality of life mean to you? What is most important for you? What risk are you willing to take? Like I said before, what's acceptable? What's not acceptable? What do you value the most? What do you fear the most? What give your life meaning? What worries you in respect to your health? What keeps you up at night? Here are some real life examples and situations that I've put on. You've got Zainab here, 70-year-old woman. She was up and about doing her own thing. She's got 3 daughters. And what she valued the most is her dignity. Unfortunately, she started developing signs of Alzheimer's, would walk around without clothes on, being forgetful. So her children decided that they were going to place her in a long-term care facility. Zainab had given her children power of attorney jointly. Unfortunately, there's disagreement between the kids because Zainab made it very clear that if ever she became old and she was not able to, that she did not want to go into a long-term care facility, that rather they should take her back home. Now the kids cannot make up their mind because they have POA jointly, and jointly mean each one of them, each individual that has been assigned that POA, they all have to come to an agreement together. If one of them disagree, they cannot move forward. So the argument was 2 of her children were saying that, for a mother to be, walking around and not recognizing objects and not dressing and having the risk to go out there and people seeing her in an image that's not really representative of her, that was not dignity. And to preserve her dignity, they thought it would be best for her to be in a facility where she could get 24-hour support and care. The third sibling decided that, no, I'm going to honor my mother's wishes. She did not want to go there, so we should send her back home. What do you do in that situation? Michelle will get into the legal aspect of all of that on his portion of the presentation. We've got John here, 66-year-old widow with 5 children. His children don't get along. He's estranged from all 4 of them. What's important for him, what he values most in life, is his independence. If he cannot have that independence, to him, there's no point of living. Unfortunately, he started developing knee pain, and his brother has been in the ICU for quite some time. And seeing his brother being in the ICU and unable to do anything and receiving total care, he said, if I have to find myself in that situation, I do not want to be, I do not want to live. Do not put me on life support. I do not want to have that. However, he did not put his affairs in order. He's estranged from his children. What happens in that situation? And then you've got Sarah, 32-year-old single parent with 3 children. One of them is still an infant. She has been in remission from her cancer for the past 4 years. But during a regular checkup, she never got to leave and return home because they found that the cancer has come back in a very much aggressive form, and she had to receive treatment immediately. Unfortunately, Sarah never was able to make it home to her children due to a most recent split from her partner. Her partner is the one that still has the authority to act on her behalf because, as per the hierarchy, he remains her substitute decision maker. What happened in Sarah's situation is the husband was choosing a treatment option that was not really the best given Sarah's wishes and values and what she stands for, but the parents were the one that was advocating for the proper treatment. There's no right or wrong answer, but it's all based on the individual, their wish and their value and what's important for them. Unfortunately, because Sarah did not have a power of attorney and because she didn't really clearly have her affairs in order, her husband or her partner that she had recently separated for is the one that is to be making the decisions for her. So you could imagine the outcome of that. So let's take a little deeper dive and look at what's the power of attorney for care. So this is appointed by the person while they are capable. So any one of us today can appoint who our power of attorney is. It requires paperwork called power of attorney for personal care. You can choose to appoint more than one person. It can be jointly or severally. The power of attorney document must indicate which kind of health and personal care decision that the attorney meaning the person that's been put in charge, can make on the behalf of the incapable person. This is not the same as a power of attorney for property, and revoking someone as your power of attorney for care or for personal care must be done in writing. This document should be specific to what type of healthcare decision the POA can make. This is something that you can do on your own, but I highly recommend that you seek the support and advice from counsel or from a lawyer. So this is a written authorization in which a capable person specified the decision, who the decision maker is going to be. No additional procedure is required or necessary to activate a power of attorney. There are forms provided by the government that you can fill out, have a witness. You have to be 18 years of age and older, and you can keep for yourself. But again, I highly recommend that this be done with counsel. So let's look at power of attorney for property, which is basically finance. This is a little bit more complex. Very similar to a power of attorney for care. A person that's 18 years of older can be appointed as a power of attorney for property. You can appoint more than one person and they could share the responsibility. It can be jointly or severally. Other people may be named It's important, and I want to stress and highlight this, that if you are doing your power of attorney for property, that you also appoint and name alternative individual if the primary power of attorney is unable or unwilling to act. It's also important to understand the nuances between jointly and severally. Jointly means all decision has to be made unilaterally with all involved parties. So anyone, if you've appointed more than one person, all of them have to make the decision together. Severally means that the appointed power of attorney for finance or for care, they could make the decision individually, right? So the attorney may be given the authority to make the type of decision related to the person property, and they have to, the act provide clear guidelines as to how money must be spent on gift, loans, and charitable donation. So what are the duties of power of attorney for property? An attorney is entitled to take, well, before I get into the duties, one thing that I need to clarify is your designated power of attorney for property is entitled to take payment at the rate set out by the law, unless you specify that no payment is going to be accorded. They are entitled to, but doesn't mean that they have to. So that is at your discretion, but know that they are entitled to, and the current rate permitted to the guardian of attorney of property, it's about 3%. An attorney for property who receives compensation is required by law to exercise the degree of care, diligence, and skills that the person in the business managing the property must exercise. If this person decides to delay the power of attorney from coming into effect, they need to make it clear within the document. As precaution against misuse, some people may choose to leave such document with a trusted third party, and most likely with their lawyer or the law firm in which they choose to do business with. So in recap, advanced care planning is really essentially a guide that helps your loved one communicate and exercise your wishes, your values, and your beliefs and your goals for future care needs when the moment comes that you are no longer to make those decisions for yourself. It starts with an initial conversation. Then you choose and you appoint your SDM if you're okay with that, or if you want to appoint a power of attorney for care and a power of attorney for finance. I highly recommend it, because when that time comes, when you've got those legal documents in place, it just makes everything much more easier and much more accessible, especially when you have a power of attorney for finance, because too often, based on experience, something happened, the legal documents are not there, the wife is left alone, she doesn't have access to the money even when the money is there, or the children or caregiver or loved ones do not have access to the money because the money is not there, because power of attorney for finances has not been established, right? It gets very complicated and it's a lengthy process. It's even more so complicated when the person is passed on and deceased and doesn't have a will, to which we'll get to it later on. And then determine what your goals of cares are. So if a health incident happened, then we're looking at your power of attorney for care. We're looking at your POA for finance. And then you have set the platform here and help and guided either your POA for care, your POA for finance, to make those important health related decisions and to consent for treatment on your behalf. Please note that your POA for care or for finance can be the same person, or it can be individual, or you can appoint as many people as you want. Or it could be the reverse. You can decide that I'm only going to have a specific individual for my POA for care, and I'll have a specific one POA for finance. Please keep in mind that regardless of who your POA is for care and for finance, think very carefully as to how you design it and if you want to give them jointly or severally. And then, very important, then the person you appoint to be either your POA for care or for finance, specifically for care, your SDM or your POA should know about your health illness. You should let them have that conversation with them. Don't hold anything back and let them know exactly what your health illness is and what's all the condition surrounding your health illness and what kind of health outcome you would like to see. Because not all of it is a long-standing, permanent, irreversible situation. Sometimes, like I showed you in the previous slide, it could be a negative health event with a temporary outcome. But like I said, you do not want to wake up and find that the wrong treatment choice has been made. Well, I won't say wrong, but a treatment choice or a consent to treatment that is not in alignment with your goals of care, or that's not in alignment with your wishes, values, and belief. A couple of resources that I've put here for you guys. Advanced Care Planning. This is a very useful site where there's tons of information. They have fillable, printable PDF form. They have downloadable quick booklets. It's in French, it's in English. They got tools and kit to get the conversation started. If you want to learn a little bit more about laws governing consent and capacity, what is a capacity assessor, here's the website. And if you want to understand a little bit more about the law governing substitute decision makers, power of attorney for care and for finance, this is where you go. All of these resources, the guide and the power of attorney, this booklet that allows you to make your own power of attorney for care and finance. Mind you, my recommendation is always to do it with counsel, is available and will be available on my website. Quickly looking into wills, and I'll pass the baton on to Michelle. What I want to say about this is we all know what a will is. And what I want to emphasize, because I don't want to steal Michelle's thunder, is no matter the size of your estate, whether big or small, if you have a home, if you own a vehicle, or maybe you don't own a home, you don't own a vehicle, you've got RRSP, you've got money in the bank. Maybe you don't have money in the bank, but you have valuable assets, you're into cryptocurrency. Maybe you've got a couple of Hermes bags that are worth 50K each, or you've got some gold. Regardless of what it is, whether big or small, even the smallest of estate need to have a properly prepared will, okay? Some of the disadvantage, if you do not have a will, is that at the time that you're no longer here, it is known as dying interstate, and your possession and asset will be distributed in accordance with strict and inflexible provincial laws. If you do not have a will, you do not have an executor, and one will be your family will have to apply to the court and have an administrator be appointed. There could also be some disadvantage tax related issue that comes with that. Michelle would get into more in-depth about wills and all the legal aspect that has to do with that. So with no further ado, I really thank you for your time today. My information is on the screen. This is how you can reach me. And Michelle, I pass on the baton to you. I really want to say thank you for taking the time to joining us today and increasing our knowledge and our awareness on such an important topic. So over to you.
Thank you, Mildred. And thank you for everyone that's signed in and logged in and has been following this presentation. With the limited time that we have left, because I want to be mindful that we have a strict cutoff at 6 p.m. The most important thing that I want to impart upon the people that are joining us is that beyond paper, the will or the goal of having your will and your power of attorney for care and property, the purpose of drafting them is really buying peace of mind. As a lawyer, as someone from African descent, Congo to be more precise, I've seen one too many times in my own family and in the community situations where, because of the absence of a will, families become torn apart, and it just becomes a circus that could have been avoided. So, and I know in our communities, there is the stigma associated with discussing death, will, estate, and it's as if you are wishing death upon someone. And I think one thing that I want us to take away from this whole presentation is that if you fail to plan, you plan to fail. And the whole idea of having documents that talk about your wishes when you're not there is actually a sign that you do care about your loved ones and what happens when you're not there. Mildred has gone at length to just talk about wills and powers of attorney for care, for property. But I just wanted to start there, and I'm going to share my screen just to show in terms of the little presentation that I had. I'm going to share just one example. If I can do that, bear with me. Share. All right. So on the screen, you have two examples. Example one, example two. And for those that are visual, I've put some lights and colors to make it more visually appealing. So example one, Lauren passed away without, let me just go full screen. We'll just go directly to Lauren. Okay. Lauren passed away without a will. Lauren had 3 children, Michelle, Amy, and Danielle. Danielle was estranged from Lauren for the past 5 years with no contact. When Lauren died, Michelle and Amy carried out the wishes of their mother, applying to the courts to be both named estate trustees and dividing everything equally between them. Danielle was not to get a share of the estate, as Lauren told Michelle and Amy for years. When Danielle found out about her mother's passing, she came looking for her cut of the estate. Once she learned that her sisters, Michelle and Amy, had already distributed the estate, Danielle then sued the estate and estate trustees, stating that there must have been an error. Her mother would have never not given her a part or a share of the estate. Without a will, the estate trustees, so Michelle and Amy, are forced to now divide the estate in 3 equal shares. Example 2, Lauren passed away with a will. Lauren met with a lawyer, just move this little screen here. Lauren met with a lawyer before her death and advised that her estranged daughter, Danielle, was not to get any share of her estate. Her lawyer advised that in order for the will not to be contested by Danielle, Lauren must leave something to Danielle, a sum of $1. The sum of $1 will show that Danielle was not forgotten about the estate planning. It sends a clear message that while Danielle will inherit her $1, she has been disinherited and will not receive anything else. When Lauren dies, Michelle and Amy carry out the wishes of her mother. They provide Danielle her $1 share of the estate and both equally split the remainder. The will can not be contested, as every lawyer Danielle will speak to will advise that she was not mistakenly left out of the will. So that's just one example, and I'm going to stop sharing here, that provides you the kind of plus value that you have working with a lawyer, someone that knows about estate planning. There's a plethora of software and AI that is out there to facilitate the creation and production of those documents. But the plus value is to work with someone, is to have these ideas, the back and forth, the human touch. And that's really what we pride ourselves at Nungisa Law. It's really putting the emphasis with the human touch, because beyond paper, because that's essentially what a will is about, it's about people. And once we understand that, I think as a community, there's going to be a shift on how we approach estate planning. There's going to be a shift in how we prepare for when we're no longer there, because it's a long but slow march that we're all in that direction. And with the help of someone that has the ability to draft those documents with you, essentially what you're buying is peace of mind. So with the 5 minutes that are left, I'm going to turn it over to the crowd if there's any questions. I'm going to put my information in the chat. The website is very simple to remember, nungisalaw.ca. And I thank you for your time. Thank you.
Thank you so much. We appreciate you, Michelle and Mildred. This is awesome. This is awesome. So this is the opportunity for you to ask questions. They are going to put their contact information and their website link in the chat. And so make sure you grab them. But now the floor is open. If you have any question for either of them.
I have a question for Michelle. Hello,
Go
Michelle.
ahead.
Hey, how are you?
I'm well, thank you. Now, my question is related to beneficiaries that might not be in the country. So as we immigrants, sometimes we don't have a lot of immediate family around us. And if you like to have your beneficiary that is outside of the country, how are they still able to access your sort of your property after you pass or something like that?
Right. And that's why the most important role, or one of the central figure in the will, is your executor. So the person that will imply or put in place or put in motion your wishes. And you want to pick someone that will have knowledge, first of all, of your family, their whereabouts, if they're back home, wherever back home is for you. And it's essentially upon the executor to go above and beyond to locate those beneficiaries, hopefully that are named in the will, but if not named in the will, then to make the necessary inquiries to make sure that, have I looked at everyone? Have I looked at all the possibilities? If it's, it's a very nuclear family, then it makes it easier. And it's also depending on the size of the estate, but it's really incumbent on the executor. And that's also a big role to fulfill, to be the one that administers, distribute, pays taxes, and files with the court whichever documents are needed to confirm that they've administered the estate correctly. So if they're outside of the country, it doesn't mean that they're not going to receive anything. It might take a longer process because you're talking about two different jurisdictions that are trying to talk the same language and read the same document. But with enough effort and the help of a lawyer that can help with the administration, it's something that's very feasible.
Thank you so much.
There's a question in the chat. Is your will only valid in one province? For example, if your will is drafted in Quebec, is it valid if you move in Ontario?
So the will is not made invalid because it's drafted someplace else, right? But you may want to have it reviewed by a lawyer in Ontario to make sure that there are no provisions that could be in conflict with Ontario laws. So it's not inherently made invalid, but it's just you would want a lawyer to give it a quick look, to run it basically through the screen of Ontario laws and typical clause that you see in wills to make sure that it complies. But no, it's not because it's drafted in Quebec that it's automatically invalid, but it's still a good exercise to have a lawyer review it to make sure every technical, typical clauses or revocation or that are specific to Ontario are there. If it's going to be, your place of residence permanently, and it just makes the process a little bit easier. Thank you, Olivia, for your question.
We've got 1 minute. Any other questions? We've got counsel in the house. Make use of it. All the charges are being absorbed by Hector.
Yes.
What is the difference, Michelle, what is the difference between general power of attorney and enduring POA, enduring power of attorney?
Maybe that's terms that in Ontario, we talk about a continuing power of attorney for property. So I'm not sure if Yomi could explain. I don't think I've come across that terminology. Ontario, enduring power of attorney. Maybe she means continuing. And if you mean by that continuing, especially for property, it means that from the moment that you sign that power of attorney, the attorney then becomes enabled to enforce that power of attorney. So we think often of a power of attorney to be only used when someone is incapacitated. But say you're traveling, you're going to Australia for 2 years, and then you have assets here in Ontario. You need someone to have access to your bank account, to manage your properties and whatnot. The continuing power of attorney, although you're just in a different location, but not incapacitated, the attorney could use that to manage your property and your finances. So I think maybe that's what you're referring to, continuing. And if that's the case, Yomi, it just means that from the moment that it's signed, it becomes enforceable. So you want to make sure that whoever you name the attorney is someone of trust, someone that will have your best interest at heart. That's why you see also the unfortunate occasions of elderly abuse, where with the strength of an attorney, ill-advised son or daughter will deplete an account, and then there's nothing you can do because they have something that was signed that was legitimate, but no one knows the heart of man. So make sure that whoever you select to be either attorney for care, attorney for property, or executor are people that are going to be with your best interest at heart. And it's 6:01. Before I give it to Mildred, I'm going to say thank you for this well-attended event. In many Zoom meetings that I've done talking about real estate, wills, or business, you get 5 people and you're happy. So there's more than 5 people. So thank you for showing up, and you have our information. Please reach out. And as you'll see on my website, it starts with a conversation. Thank you.
Thank you. Thank you, Michelle, for your time, and thank you for being here. It is greatly appreciated among all of us. There will be a survey link that Hector will put in the chat for people to complete, please. That is your opportunity for us to hear what it is that you would like to hear from us. We are here, dedicated, willing to work and support and serve all of our people within our community. So your feedback is very much important and very much appreciated. Please take the time to complete that survey, and then we will communicate the result of that survey and the feedback with everybody that has been here today and that has registered for it. Thank you so much for your time. Do reach out.
Give me one moment. Let me put it in the chat here. Mildred, if you have it, put it there for me.
Okay.
Do you have the link?
I have to go get it.
Give me one moment.
If not, you will receive an email as well
Trying to pull it
with the link.
I think I got it here.
So we thank you. I'm going to stay on a little bit for those that have any question, but if not, thank you so much for your time with us today. And thank you, Michelle.
Most welcome. Take care. Bonne soirée à tous. Au revoir.
Merci. Bye.
All right, thank you. Give me one moment. I got it here. Okay. There's a. Where is it?
I have a question.
Go ahead and ask.
It was an overloaded information. All I asking, if we want to make such a big decision, and how do we go about it?
Start by having the conversation with your loved ones. Okay. Then identify what's important for you. What do you value the most? What does quality of life mean for you? Ask those conversations, ask those questions. It gets uncomfortable, but it's okay. The more uncomfortable you get, that's when you know that you are on the right track. Once you've determined and you've identified those things, then decide as to, are you going to stick with a substitute decision maker, or you want to designate a power of attorney for care, and you want to designate a power of attorney for finance. Once you've identified who those people are, the next thing that you need to look into is those power of attorney for care and for finance, do you want to give them, appoint them jointly or severally? Are you going to have one individual, or is it going to be multiple individuals? And then the next decision that you need to have is, are you going to do it yourself, or are you going to seek the help of counsel? And from then on, you get into wills and estate, because that is different. Keep in mind that advanced care planning is not for when one is no longer here. It is for actually when you are here, and what do we do? Unfortunately, sometimes the situation take a negative turn, and then that individual that was once among us is no longer with us. That's why it's important that when you're having this conversation about advanced care planning, that you tie in the conversation about wills and estate planning, because they all go hand in hand. And then if you are going to get counsel to help you, well, counsel will, when you are going with a lawyer, they are going to cover it all, because when you're going to be doing your wills and estate planning, they will ask you about your power of attorney for care, power of attorney for finance. So in all, how do you start? It starts with a simple conversation. And it's okay if you're not ready to have that conversation now. At least you have given the platform, you have gotten the information, and you have been given resources, and you know where to go to should you have questions, or do you need further help or clarification. Excellent question. Thank you.
So much.
Any other question? The survey link is in the chat. Please take the time to complete the survey link. This is going to give us opportunity to help you and see what other topics that you might be interested in or want to learn about, or what other topics that you think affects our communities that we should shed some light on, or do education webinars or seminars or workshop on. So please take the time to complete the survey. If there is no question, I will give you your time back into your evening. And I trust that everybody is doing well. And thank you once again for joining us. And thank you to our sponsor, and thank you to Hector.
Thank you so much. That's awesome. That's an awesome presentation. We are happy to have you and Michelle do this for us this evening. And I know somebody is just joining. I know we will have a repeat somehow. So thank you so much for coming. Mary, you just joined. The meeting just ended. So, but fortunately, we recorded it, so you'll be able to play back the video. Okay. Thank you so much.
Okay. So are you?
Okay, thank you, everybody. Have a good evening.
Good evening, everyone. Thank you so much for joining. Those of you who joined late, we'll have the recordings and we'll share it. If you go to our YouTube channel, you'll see it as well. Thank you so much, and we appreciate you coming. And then look forward to another email for another workshop. Bye.